Tom?
I'd like to read part of the what's titled the referral report from Samuel Gold, AICP, Senior Planner, Regional Planning Commission, Council of Governments of Central Naugatuck Valley, out of Waterbury. It's addressed first off as the Zoning Commission Chairman of Woodbury. There's several other addressees on there. I'm not going to start with the first paragraph. It doesn't really pertain to this, other than to mention the proposed amendments to the zoning. And it goes on to talk about how the COG, CNV staff finds proposed amendments, and there's quite a few numbers there, to be in conformity with the regional and state plans of conservation development. The proposed changes to section 3.22 and 6.2 directly support the regional plan's major recommendation to, quote, protect the quality of the region's water supply, end quote. However, the staff has concerns about proposed section 7.5.10 political signs and a recommendation for a proposed section 8.2.12.d. Proposed section 7.5.10I, political signs, limits the allowed square footage of political signage. Political speech has been given special protection in the U.S. Constitution and numerous U.S. Supreme Court decisions. A government may only restrict political speech where there is a compelling threat to public health, safety, and welfare. Any remedy to this threat should be content neutral and not too broad. The stated purpose of Woodbury's signage regulation is, quote, to provide the appropriate balance between the need to protect health, welfare, and safety, and property values, end quote, section 7.5.1. Stating that the regulation protects health, welfare, safety, and property values is not the same as establishing what danger signs pose to the public and how a cap on sign square footage remedies that threat. Either stating the rationale or making a reference to it from another official town document may be helpful in defending this regulation in court. Staff recommends consulting with an experienced land use attorney about this proposed regulation. Proposed section 7.5.10.I sets the maximum sign area of political signs to be the greater of 12 square feet or, quote, the maximum aggregate amount of signage which would be allowed on the property under the regulations applicable to the district in which the property is located, end quote. It is unclear what is meant by, quote, maximum aggregate amount of signage, end quote. Staff has a few questions. Does the maximum aggregate amount of signage include all types of signs, including temporary signs? A chart showing maximum square footage of permitted signage by type and district would be helpful to include in the regulation. Does this proposed regulation effectively double the square footage of signs allowed on a property for the purpose of political speech? Could this undermine the town's assertion that signs are a public hazard? Is this sign regulation content neutral if it gives special privileges to political speech over other types of protected speech, i.e. religious? An example of a content neutral sign regulation would be to set a maximum aggregate square footage for all signs on a property within a district and allowing the property owner to decide how to allocate signage square footage. Political and other permitted signs will be allowed as long as this maximum is not exceeded. If signs already on the property meet or exceed the maximum sign square footage for the district, no new sign of any type would be allowed unless something is taken down. Care would have to be taken in setting the aggregate sign square footage maximum for each district. Staff did notice that the existing sign regulations do not specifically list signs with religious messages as permitted in any zone. Are property owners allowed by right to place a sign with a religious message such as Merry Christmas, Happy Diwali, or Jesus Saves on their property, or would they need to obtain a permit? Proposed section 8.2.12d postpones the expiration of approved special permit site plans. Staff suggests making a connection between the contents of this section and Public Act 11-89 more explicit. Once the economy in the building sector improves, this Public Act may be amended or repealed, and language could be included that ensures Woodbury's regulations stay in conformity with the Public Act if it is changed. As we've stated before, in the past, the Supreme Court has upheld that if there are larger signs allowed anywhere in town, the political signs can be limited, but it's generally wherever the largest sign is. And we do have out-and-out billboards. A 4x8 isn't a billboard. It may be a component of a billboard. We can look at the sign across from the charcoal chef. We can look at a lot of the signages that are around town. We can also look at what was mentioned last time. I mean, the Christmas lights up here, that's effectively conveying a message. It's signage. I mean, how many thousands of square feet have we just had out in the recent few weeks? That's out there. How about the creche down the street? That's basically a sign. And these aren't complaints about this, but to try and narrow down political signs and curtail freedom of speech, I'm dead set against.
All right. I'm sorry, Tom, can I ask you a question? You've read what you just said.
No.
Do you have alternate language that you think would improve on that and address what you just said?
Yeah, well, what I would suggest as far as an alternate to what you propose is I support the defeat of all proposed regulations. It's clear that we need to start over and have all commissioners involved in writing them. I'm bothered by the refusal of Commissioner Overton to release relevant legal opinions so the public can review all relevant information. I urge the repeal of well, you're getting my opinion.
On the record, relative to the particular item, 7.5.10.1, is if you have, and you just read, as far as I understood.
I contend that you can't curtail political signs as an expression of free speech, and it ought to be repealed.
Thank you. Thank you very much.
And that's one thing that you continue to do. I also think that, and I'm making a request right now that this public hearing not be closed tonight, and that be extended to the next meeting. Reason being, you have just given us the legal opinion. I don't even have the aquifer protection one. All that was in the stack that came to me was on the zoning regulations. And if we've just been given that, we really haven't had any time to mull it over. The commissioners have had no time to mull it over. We can't have an educated decision on it. It's basically being crammed down our throat. And I don't consider the duration of tonight's meeting sufficient time to give a valued judgment on it.
I want other people to have an opportunity.